Hello, we are back. Yes, we are. And today, Get Legit LLC is bringing to you a topic we've never discussed before, but a topic nonetheless that is deserving of our knowledge. So let's get into it. But before we do, please hit that like, share, and subscribe button. Comment to our contents. Let us know that this is the kind of information that you all would like to receive so that we could prepare more as it relates to these kinds of recordings. As you can see on the screen, Chrisley's knows best. Yes, we will be discussing Todd and Julie Chrisley's trial and their appeal. March 29th, 2023, their attorneys filed their appellate brief. And so we're going to look at two issues in that brief, in particular, having to do with asking the question and trying to see if we could answer it. The first question is, was there prosecutorial misconduct in their trial? And the second is, was there issue of fruit of the poison tree, having to do with cases where certain documents or certain email and documents that were let in the trial after a court would have ruled that the search warrant was unconstitutional. No, it doesn't mean the entire search warrant was, but a particular section of it was. I'm also going to look at what happened before the magistrate judge prior to trial as it relates to different motions that were brought by both Todd and Julie's attorney. So let's get into it. Most people would know this family. If you watch the show, you know who they are. It's a wonderful show. I used to always watch it. I used to love Granny Faye. I used to love Chloe. I mean, not used to, I still do. But it seems, I want to suggest from looking at the indictment that was filed, that these people's lives weren't as grandiose as they would want us to think. The reality, it would seem from reading the indictment, is that they really put on a good, quote unquote, show for us. So let's get into it. Let's see what all that was about. Okay, so just a quick recap. Todd and Julie, they had a trial May 16, 2023. They were found guilty of 12 counts of bank fraud, bank and wire fraud, and tax evasion. Conspiracy charges as well. I believe the conspiracy charges were to Julie. Nonetheless, they were accused of submitting false documents and when applying for rental property and loans. Now, the couple were cleared of any tax evasion charges state-wise, and the state at the time they were living in is Georgia. So they were cleared of state crimes, okay? And that was November 21st, 2020. Oh, well, they were cleared of state tax evasion charges. However, the federal tax evasion charges still loomed over their heads. And so they were convicted in June 2022 and sentenced November 2022. And by January 2023, they filed a slew of motions, and we're going to look at some of them, not all, but look at some of them that we believe can lead us to an answer as it relates to whether or not there was prosecutorial misconduct. I'm not going to answer the question. I'm just going to give you a snippet of what is before the court in their appellate brief, what transpired or the attorneys claim transpired in the trial. It should be a matter of fact now as it relates to the evidence before the court, and let you all make your decision. So let's entertain ourselves. Let's converse among ourselves and see to our mind whether or not we believe there was prosecutorial misconduct by Todd and Julie. Now, bear in mind that a third person, their accountant, was also charged, tried, and convicted. But I won't spend much time on his appeal because I haven't seen his appeal as yet. I will only speak as it relates to Todd and Julie and do a brief thing as it relates to Tarantino, where he made an application or a motion to sever. So just to look at what was said by the U.S. Attorney Ryan K. Buchanan, he said that over the course of decades, the Chrisley'S defrauded financial institutions and the federal government through tax evasion and other fraudulent means in an effort to minimize their tax liability, but project an image of wealth. And we all saw that image of wealth. Okay, so they further explained that the Chrisley'S failed to file tax returns or pay any tax for 2013, 2014, 2015, and 2016. And as a part of the tax evasion scheme, Tarantino, who is their accountant, was convicted of filing 2 false corporate tax returns for a loan-out company, which falsely claimed that the company earned no money and made no distributions in 2015 and 2016. So let's get into it. Now, bear in mind, this is what the U.S. attorney is saying. The reason why these people were charged. Pay close attention to those years because they will come up in the trial and in the appellate brief, okay? This is a copy of the indictment that was filed August 30, 2019. Oh, that's my daughter's birthday. Cute. Anyway, moving along. So I just picked out a certain sections of the indictment that I think is telling and I think is shed some light as it relates to what was the case about, what were the allegations that were before the court. And just to give you an idea, and because I'm reading directly from what was put in the indictment, you're going to hear me use some curse words, but it's just in the actual word. I'm just going to say the initial letter for that particular word, okay? Don't want YouTube to strike my video. So at paragraph 18, and you all can feel free, go on the internet, type in these information, and you'll be able to find that indictment yourself and take a look at it. So paragraph 18 of the indictment reads, throughout the conspiracy, the conspirators, and that's Todd and Julie, when they say conspirators, submitted false documents to banks. Okay, conspirators mean Todd, Julie, and the accountant, okay? So the conspirators submitted false documents to banks when applying for loans, including fabricated bank statements listing inflated account balances, personal financial statements containing false information about available funds, false invoices, and false audit paperwork. For example, on or about November 5th, 2007, co-conspirator A sent an email to a bank that copied Todd Chrisley attaching a personal financial statement that falsely claimed Todd Chrisley had $4 million at Merrill Lynch. When the bank employees requested account statements, co-conspirator A sent Todd Chrisley a fabricated bank statement showing that Todd and Julie Chrisley, his wife, had $7.76 million on deposit at Merrill Lynch. In response, Todd Chrisley told co-conspirator A, and I quote, you are a effing genius. Just make it show 4 million plus. Close quotes. In actuality, Todd and Julie Chrisley did not have a Merrill Lynch bank account at that time. And after They later opened one in 2008. They never had more than approximately 17,000 on deposit there. As a result of false representations like these, a number of banks issued the conspirators millions of dollars in loans, much of which Todd and Julie Chrisley used for their own personal benefit. At paragraph 19, it says, at various points during the conspiracy, Todd Chrisley personally directed co-conspirator A to send false information to banks. For example, when one bank provided notice in April 2008 that it would not be able to renew a loan without updated financial information, Todd Chrisley instructed co-conspirator A, and I quote, please get her the financials and I will get her the rest, close quote. After co-conspirator A responded, open quotes, I don't have financials on any of these. She has tax returns, close quotes. Todd Chrisley wrote, open quotes, stop telling me this shit. Create them like you always have, close quotes. If I don't get these, then, no, I made a mistake. Todd Chrisley wrote, blah, 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 stop telling me this shit. Blah. Do as you have always been doing. If I don't get these, then they won't renew the loans. When another bank provided notice in 2008 that it needed updated financial information, co-conspirator A told Todd Chrisley that he or she needed assistance in putting the requested financials together. This prompted Todd Chrisley to write, open quotes, giving me an excuse as to why you cannot figure this out does not move it off your plate. This is not what we discussed. Passing it back and forth is not getting the results requested. If you do not know how to do this, then find a crooked accountant to do it. Redacted means certain things were taken out, okay? So ask who her guy uses for his crooked shit. Now, if you look at that, that means who is the her they're talking about? The only her we've been discussing all along is the her from the bank who was asking for updated financials information. And he says to get a crooked accountant. And then he said, ask, and they redacted it. So that means they changed up some of the things were taken out for whatever reason, who her guy uses for his crooked shit. At paragraph 20, it says, the conspirators continued sending false information to banks even after receiving the initial loan disbursements. At times, they did so in hopes of renewing certain loans. At other times, they did so to conceal their financial difficulties and to prevent the banks from seeking legal remedies to recoup the outstanding loan balances. For example, on August 27, 2009, a bank representative notified Todd Chrisley and co-conspirator A that the last personal financial statement we have on file, June 2009, looks a lot like the December 31st, 2008 statement we received. Cash, securities, and real estate, all exactly the same. We have a review coming up and would like to show this accurately, and no one asks questions as to how these could all be exactly the same 7 months later. So they're telling them, you all gave us information that's the same as it were 7 months before. And now when we got updated information, it's the same thing. And so they're saying, so that no one asks questions as to how these could be exactly the same 7 months later, we need updated statements from you. Todd Chrisley forwarded this message to co-conspirator A and stated, quote, "Bring the securities down significantly," close quotes. The bank representative further notified Todd Chrisley and co-conspirator A that we have a FDIC examination beginning on September 14th, and your file will be one they will review. Any assistance that you can provide here to update your statement would be appreciated. Note how accommodating the bank seems. Note how, even though information not updated, the bank is edging, assisting, or I don't know what you call it, but it just seemed like a different world for certain people. I could just imagine if you and I have any documents before a bank that aren't up to par, will we get this courtesy email or call? Let's move on. Todd, no, this is what they're saying happened as a result of those emails, okay? Todd Chrisley forwarded this message to co-conspirator A and stated, quote, open quotes, "This is why the personal financial statement needs to reflect what you sent regions and the FDIC. Similarly, when attempting to provide evidence of available funds in April 2012 to a lender, Julie Chrisley, the good wife, forwarded a copy of a check to co-conspirator A and Todd Chrisley and instructed co-conspirator A that post date is the only thing that needs to be changed." Now, when you say post date, what you mean is that you're going to put a date back. So today is the 15th. Post date means you put it for the 11th of this month. Okay. The attached check stated that it had posted to a bank account on February 8, 2012. Todd Chrisley then instructed co-conspirator A to, quote, open quotes, "Make sure this is perfect before you send it to, as there can be a screw up and she looks at this stuff fairly close." Now, when you see redacted, that means certain things were taken out, okay, for whatever reason. Shortly thereafter, co-conspirator A emailed Todd Chrisley an altered copy of the same check, falsely showing that it had posted to bank account on November 1st, 2011. The conspirators, Alianaska, please be quiet. I'm trying to be great here. My apologies, people. The conspirators also used Chrisley asset management funds to pay them outstanding bank loans or for their own personal benefit. The conspirators did this despite knowing that the company often had outstanding checks or debts that would not otherwise be covered by the remaining balances in its bank account. And as a result, Chrisley Asset Management began to have significant financial difficulties. Todd and Julie Chrisley. They were convicted, sentenced to years imprisonment, and now here we are, March 29th, 2023. They filed their appeals. But you might be asking, what really was this about? What really happened at trial? What were those motions that they brought before the trials? Well, from their appeal, two things seems to be issue. All right. After they were convicted, they filed several motions. The same way they filed motions at the beginning of their trial, they filed motions at the end of their conviction. I hope Tasha K's attorney is listening. So motions for acquittal were filed, motions for a new trial, and motion for resentencing were filed, but they were all denied. They appealed the 11th Circuit Appellate Court, asking for a stay of their sentence, meaning when you say a stay, you mean to stop it, to make it seem as though we've never been sentenced, to put a halt on it and make us free, go free until you hear whatever. So they won't have to be in prison while this is going on. But that was denied. They later appealed for bail pending the hearing of the appeal. That too was denied. So where you have an appeal before the court and you believe your appeal is strong, and there's a high probability that you will be successful on your appeal, what they're saying, could we get bail pending the hearing of the appeal, because we've shown our appeal is so strong that we believe we will be vindicated, or we believe that we will be given another trial. And so they're asking for bail, but that was denied too. So their attorney, in his appeal to People Entertainment TV, their attorney's name is Alex Little from Brewer and Foreman LLP. So the attorney said two things, and those are the two things that I will be looking at in this appeal. The very beginning of this case, and I'm quoting what the attorney said. The very beginning of this case, there was an unconstitutional search by the Georgia Department of Revenue. Little claimed in an interview with Entertainment Tonight, so that's what he's claiming. He continued to say, this court already found that that was unconstitutional and it should have stopped the whole case in its tracks. That didn't happen. And that's certainly one of the things we're pursuing on appeal. Hence the reason why in this video I'm asking, is there an issue of fruit of the poison tree? Continue on. He said the second piece is one of the IRS officers testified about whether the Chrisley's had paid certain taxes. That certainly, we think, affected the jury, and we believe it will be a basis for a new trial. Let's get into it. So from what he's saying, two issues, fruit of the poison tree and due process. So as again, appeal was filed March 29th. Julie appealed, she's appealing, she's arguing that there wasn't enough evidence to prove the bank fraud, and she's also appealing the sentence. Todd, he's appealing the same things as Julie. There wasn't enough evidence. There wasn't enough evidence appealing the sentence, but his goes a bit further. He is also raising arguments and stating that the IRS agent's testimony was improper because it was not factual, which means she's saying basically in a fancy way she lied, given the circumstances as they stood when she testified. Further, I know the spelling error. The fact that the court ruled the search warrant to be unconstitutional, yet that same search warrant led to documents and other evidence that were obtained and led to his conviction. So those two issues was their prosecutorial misconduct and fruit of the poison tree, because you're saying a search warrant that the court said was unconstitutional, and by virtue of that search warrant, certain actions were done. They went, they searched, they gathered information, they gathered documents, they gathered things, and they're saying it flowed from an unconstitutional search warrant. So that means whatever you got under that search warrant should be out. Hence the reason why we say fruit of the poison tree. Okay. So let's look at the motions that they brought before the trial, because they did brought several motions. So the defendant, Todd Chrisley and Julie Chrisley, together brought a motion to suppress evidence. Suppress means they don't want people to hear it. They don't want the court to hear it. They don't want the jury to hear it. To suppress evidence seized pursuant to the search warrant for the emails and electronically stored information. The Chrisley defendants timely filed objections to the R&R, to which the government did not respond. In their underlying motion, the Chrisley defendants moved the court to suppress various electronic evidence seized pursuant to 3 search warrants. As the R&R observes, the Chrisley defendants argued that the warrants were not sufficiently particularized. The government exceeded the scope of the warrants and acted unreasonably in their execution. The magistrate judge found that the language in the warrants, while somewhat broad, in defining the categories of documents authorized to be seized was sufficiently particularized, especially considering the broad and complicated nature of the evidence relevant to this case. Next slide. Further, the magistrate judge found that the two-step process when directed the email provides to initially produce the entire contents of the subject accounts for the government's review was expressly authorized by the warrants themselves, although the government could have included more restrictions throughout the warrant application attachments regarding a date range and names of specific persons for the intended evidence. According to the magistrate judge, however, these issues did not deprive the warrants of its facial validity. More notably, the Chrisley defendants have not alleged that any emails are due to be suppressed for falling outside of these suggested restrictions. So, those were two of the motions that the Chrisley, Todd, and Julie brought. Now, let's get into Tarantino. He's the accountant who was also a defendant along with Todd and Julie Chrisley. He was convicted and sentenced to 3 years in prison. So he brought a motion to sever. He didn't want his trial to be heard with these two people. He wanted to distance himself, as he had a right to, right? So let's get into what the court decided in his application, motion to sever. After properly setting forth the standard for when a severance is appropriate, pursuant to Federal Rule of Criminal Procedure 14, the magistrate judge cites the risk of prejudice to defendant Tarantino as the primary reason supporting severance based on an email composed by one of the defendant Tarantino's co-defendants. The email referenced a desire to engage a crooked accountant, which, according to the magistrate judge, jurors may wrongly believe is the defendant Tarantino, or alternatively, that the defendant Tarantino was hired because he fit that criteria of a crooked accountant. The magistrate judge also mentions that the overall disparity of the evidence against each of the three defendants is at least relevant to, if not specific, basis for his recommendation for severance, especially since defendant Tarantino is alleged to have been involved in only one of the co-defendants' 3 purported fraud schemes. Although the court acknowledges the magistrate judge's concerns, these concerns are not unique to conspiracy cases such as the matter at bar. It is often true that not all alleged co-conspirators are charged with committing the same acts or being involved in exactly the same aspect of an alleged conspiracy. However, this does not change a general rule that defendants who are indicted together are usually tried together, especially in conspiracy cases. Having considered the concerns presented in this particular case, the undersigned finds that they may be addressed with proper limiting instructions that make clear to jurors which evidence applies to each defendant. In other words, court finds that the jury will be capable of sifting through the evidence to make an individualized determination as to each defendant. So what the court is saying, that even though they are seeing certain evidence that will be before the court could raise issue of prejudice and warrant a severance, they're saying that the normal practice is when you have a conspiracy cases, everybody are tried together. And moreover so, even though they see that issue that the jurors might think, oh, when they talk about a crooked accountant, you fit that you're the person they're talking about. Even that might be the case, they're saying that there is so much evidence having to do with each of the conspirators that the jury would be smart enough or mindful enough or will know what evidence is going for who, so that there is no need for them to sever. So that means Tarantino was tried along with Todd and Julie Chrisley. And so the jurors would have heard that when Todd's email was read saying, just find a crooked accountant, and him being the accountant, the impression you could get from that is that, okay, you're a crooked accountant, you're crooked. That's the court position. They believe that it didn't prejudice him. They believe that he had a fair trial or could have a fair trial, even though that would have been known to the jurors. What do you think? Let me hear your opinion in the comments. So now we're at the appeal, Todd and Julie Chrisley's appeal. So the two issues the attorney said in his interview having to do with unconstitutionality of the search warrant, and which raised the issue of fruits of the poison tree, and as it relates to the testimony of the IRS officer when it comes to how matters stood at the time when she testified, where they're saying basically she lied, whatever. Those are the two issues I'll be looking at. Okay, so the three issues are here, and it's saying what I just explained. Whether the district court abused its discretion when it refused to hold a hearing on the defendant's gigolo claims. You might be asking, what a gigolo's claim? Well, a gigolo's claim is where any evidence or any materials or anything that the prosecutors they have, they must disclose it. They must bring it to the court. And I will explain that in the end as it relates to the Brady case, where that came from, and the gigolo case, okay? Specifically, that the prosecutors knowingly presented and failed to correct false testimony from IRS Revenue Officer Betty Carter, who lied about defendants owing taxes for years when she knew no taxes were due. First issue. Second issue, whether defendants' Fourth Amendment rights were violated when the district court admitted volumes of excluded evidence at trial without requiring the government to prove it, obtained the evidence through a source independent of its unlawful search. So what they're saying here is that the court ruled the search warrant to be unlawful, unconstitutional. The evidence that was before the court, volumes of evidence before the court never required that the prosecutors prove how they come to having those evidence, those documents, those emails. Because they're of the view that had they done so, they would have seen that all that they got and that they used before the court would have came as a result of this search warrant, fruit of the poison tree issue. And the third issue that we will not be dealing with in this, because I want to follow what the attorney said in his interview, is whether the government offered sufficient evidence at trial to convict the tax evasion and conspiracy counts 8 and 9, when it proved only that the defendant lawfully received his acting income through a loan-out company, which is standard in the industry